Clinton Dixon.
That's right.
Yes. All right, and what is the update?
I did receive an email back from the handling and intake attorney. The robbery cases is with the paralegals. He's asked for it to be sent to him so he can evaluate it for a charging
All right.
decision.
So,
So no decision, I guess, no decision at this point, but at least the ball is rolling that way.
all right, so what time, when do y'all want this called back? State, how much time do you need?
Yeah, I mean, I imagine if he gets the case today or some point, I think he should have it in the next couple of weeks, or she should have a decision to make within
All
a
right, do
couple.
y'all want to bring it back the week of December 16th? Is that good for you, council?
Everyone is packing that last week,
We can do it the week before.
no, even that week before, it's just packed. We'll do the 16th, Judge, we'll come in on the 16th.
All right. Norma, if you can recall this for December 16th, please.
Thanks, Judge.
You're
So
welcome.
maybe it's Tuesday.
Yes.
I don't even know what's going on.
Oh, okay. So let me tell you what's going on. So your attorney, he cannot go forward on this case. I know you said that you wanted to enter a plea on this case, but the problem is you have outstanding cases. Your cases are in intake. What that means is that there's a prosecutor who's reviewing your case to see whether your case should be sent to indictment, to see whether or not they have all of the discovery, so that your attorney can have that and give you the information you need to make an informed decision. For example, on this case, it's an unauthorized use of a vehicle. If your attorney were to give you advice and you were to enter into a plea on this case, you still have those cases pending, so you will not be released. The state is trying to move as quickly as possible. Your attorney is trying to move as quickly as possible. And I know your attorney is moving towards trying to have you released. So we're coming back on December 16th. On December 16th, he will have the information he needs so that he can give you advice that is good advice. You understand?
So what gonna happen with the case of the lesson on the ground? But they still haven't got no test results. If
All
it
right,
passed
so
90 days.
here's the thing, you have more than just that one case pending. So that's the problem. Now, what I can tell you, usually on possession less than a gram cases where there are lab reports that are not in, then something else will happen with that case. You understand? All right, thank you so much.
Maybe it's Tuesday.
Yes.
Thank you.
Do you need to take a break? Just 1 second. What page is Andrade on? Roberto Andrade. Kevonta Thomas?
President. Ready.
And after Thomas, it would be Day, then EU, Mejia, Delarosa, Smith. All right.
This is just. Yeah, on the scaffold.
All right, where are we on this case?
Judge, last time we were here, I believe was October 28th. They provided us with a scan disc
Mhm.
and we're still trying to go through all of that material on that. So we're needing some additional time with the discovery aspect.
So you actually have all discovery?
What I've been able to review, Your Honor, I believe we do, but I'm still in that process of trying to make that determination.
All right, Norma, recall this for January 6th. State, were you able to tender an offer in this case or no?
We have not received an offer yet.
All right,
Judge.
state, on January 6th, an offer will be due.
Yes, Sean.
Thank
All right,
you
is
very
there
much.
anything else?
That's all on that matter.
All right, thank you for addressing appropriately for court. It's Kevonta Thomas.
Thank you, Judge, and you have a happy Thanksgiving.
All right, you too. All right, what can I just? Thank you.
Okay.
After being on the run for over 2 decades, this murder suspect was ultimately tracked down in Mexico. A man who has evaded custody for over 2 decades after allegedly murdering a man has been tracked down and arrested in Mexico. Jose Armando Mejia has been on the run since 2002 after police accused him of shooting 3 people, including a 6-year-old boy, when he opened fire at a house after an attempted drug deal in San Antonio, Texas. Out of the 3 victims, one man named Leroy Campos died from his injuries at the scene. The shooting occurred on April 26, 2002, when Mr. Mejia and 2 other men went over to Campos' home for a drug deal. Mr. Mejia allegedly grew impatient while waiting for the narcotics and left, but later that night, police say, he came back, barged in and opened fire. Campos was shot in the head, while the 2 others, including the young boy, were injured in a gunfire. Police say that Mr. Mejia had been on the run for all that time, until May 4, 2024, when the suspect was tracked down in the small city of Nava in Coahuila, Mexico. That discovery came after the Lone Star Fugitive Task Force, along with the U.S. Marshal Service, adopted the case in March 2024, with 2 arrest warrants for Mr. Mejia. During its investigation, the Marshals received information on Mr. Mejia's whereabouts and movements in Mexico. The task force then worked with Mexican law enforcement to find the fugitive, and he was ultimately arrested after evading justice for decades. After his arrest, he was turned over to U.S. Customs and Border Protection and is currently being extradited to Bexar County.
Jose Mejia?
That's us, sir.
Oh,
After this, or now if you want.
okay, I'll do it after this.
I sent you a message
Okay,
on a non-related matter. The 2 pictures are free to look at.
okay. Yes, thank you so much. Oh, thank you. All right, Jose Mejia, we are here for discovery.
The judge, I spoke with the defense counsel, this case is a 2002 case. We do have a VHS tape and a cassette tape.
Is it beta?
No, it's VHS. I'm aware, I'm old enough to know which one's which.
Okay,
But I have gotten that just recently, yesterday actually, transferred to a disc, and also the cassette transferred to a disc. Process of making copies of that, and I don't know if they have receipt of all the reports or not. But there's also photos, and the photos are also hard copy photos. And I don't believe they've seen those.
I've not seen that.
But those have been in the file, but I don't have the file here today because I was looking at it yesterday.
all right, so here's the thing. This is gonna be recalled back for discovery in January.
Okay.
But help me understand, I know sometimes things are indicted late or something else has happened. So since this case has a 2002 indictment, why is this so late in appearing in this court? Because I have our first date ever on this case in this court was July 2024. So I know there were some issues with discovery then,
Yeah.
so,
He lived elsewhere.
okay. All right, that explains things. Thank you.
Explanation.
And the reason why I'm asking that is because now they want us, of course, to put all our notes in discovery, and I'm a stickler for having notes in discovery. And so I just want to know why that's the reason, because as you know, see, breaking things. You know what this reminds me of? Yeah, I'll blame it on Charles. When we were growing up as a child, you would be allowed to sit on the sofa, to eat something. But if you spilled something, my grandmother, my mom would say, okay, they're not ready to sit on the sofa and it's back to the table. So I don't know if you're ready. Yes. All right, so what date in January for discovery, Mr. Bunk? I know you have a trial with us in December.
Yes. January, I'm flexible, so whatever pleases the court.
All right, well, state, how long do you think it'd take you to find a VHS player? I had one until the great flood of 2023.
I believe I have that all, I believe it's all being copied right now by our IT department, so I don't think that'd be a big problem. I don't know how to do the photos other than let them view the photos, because making copies of those would just be, I don't know,
Scan them into.
if I can find somebody to scan them. But I mean,
I know Walgreens and CVS does that, but they can tend to get very pricey. And then they may call the police depending on what it is.
well, these pictures, they probably would be.
Okay, So this is what you all will need to figure that out. We'll
Okay.
call it the week of January 27th.
Okay.
So what date? You got the 27th, the 28th, or the 30th?
30th,
Okay,
30th?
yes.
all right. We'll be back on that date for discovery.
And I filed some bond reduction motions. Can we get a date? Or can we get those heard at some point before then?
If the state is ready, we can hear them for this afternoon. If not, we can
Judge,
call
I
it
do
back
have-
in December.
Just to let the court be aware, I have a meeting with the admin at 2 o'clock that I have to attend.
We can
Okay,
do-
so
we can do it the first week, you know, when I'm in here with you, the end of that first week in December.
That'd be fine.
Let's do this. You all confer on a date
Okay.
that both of you all can decide on, and we'll hear it at that time.
Okay,
So
thank
I
you.
won't set it now, but your attorney will confer with them.
Okay.
Thank you.
Thank
All
you,
right,
Judge.
thank you. Thank you.
Have a nice day.
Oh, thank you. All right, everyone, we're gonna take our recess. Who is here? Who's ready to go now? If it's for a plea, we're gonna have to bring it back this afternoon, but who's your client? Prado. Can I see your file on Prado?
Your Honor, also, I'm here for trial announcement as well.
All right,
And I think you called mine already. So
all right,
we're-
Prado, come down.
Jesus Prado went to pick up his kids when he got into an argument with the woman who was inside the home. That is when the suspect began dousing the house with gasoline and threatening to set it on fire. Police tell us he was holding a torch. One of the officers reported that to dispatch, and that is when the suspect began to barricade himself inside the house and started shooing from a second-story window with a long gun. The first officer was hit 3 times, and the second officer was hit as well, but he was able to go in the car to retrieve his gun to return fire. Both officers were pinned down. The officer who was able to return fire found that he needed to move back further to give himself more distance because he was still being fired upon. Shortly after that, officers rode down in their patrol vehicles and extracted both officers, and that is when the suspect surrendered. Both officers were seriously injured. The suspect will be charged with attempted capital murder.
All right, this one, let me see, I don't have a single docket sheet on this. All right, where are we on discovery?
I believe discovery has been exchanged, Judge. We were given an offer that has been rejected. It looks like it's gonna be a trial case.
All right. So I'm gonna set this for a jury trial date and a plea deadline date.
Okay.
All right, if you all wanna, because I see the charge. If you all wanna confer with Ms. Ferguson on a jury trial date and a plea deadline date, and then come back and let me know what date that is.
Thank you, Judge.
All right, thank you. Thank you.
I want to take this.
They need to confer with you on a date.
Your Honor, I have Delarosa.
All right, Ray Delarosa.
Ray, please come on. Good afternoon, Your Honor.
Good afternoon. All right, today is plea deadline date
It is, Your Honor.
and,
My client had rejected,
all
my
right.
client had rejected the state's offer. So.
So we have a DWI third and a assault family and a violation of protective order.
I think there's 2 assault families.
All right, so what date?
What? in
For
Jan-
jury, yeah,
in
it'll be a date in January.
Which date would be good for the court?
Ms. Ferguson, I need a jury trial date for family violence in January, please. And it's Ray Delarosa.
Yes, Your Honor.
All right, just one second. All right, January 14th it is.
January 14th, Your Honor.
Yes.
On discovery, I think I had got a notice for additional discovery. I was trying to download it on the e-discovery.
All right, this is what we're gonna do. Norma, have them come back on December 19th for discovery and then hold that trial date. And if you've received all the discovery by then we'll still give you that trial date.
Thank you, Your Honor. I'm going to give the state a thumb drive,
All right,
and that should take care of everything in discovery. On the 19th, correct?
yes.
Thank you very
December
much.
19th.
Thank you very much, Your Honor.
All right, thank you. So Norma, if you'll give them a reset date for December 19th. Yes, and just put it for discovery on that date.
Thank you, Your Honor.
All right,
With
once you
pleasure.
sign the reset form, you're excused.
Thank you,
You're welcome.
Your Honor.
Yes.
You know what my ideal career would be?
What?
Owning a chocolate bar factory.
Oh, that would be so awesome.
You have a good day. Thank you,
Right,
Your Honor.
too. All right, Jesus Prado, have you got the date yet or no? Okay. And then after that, we're on our reset. Who do you have?
Mr. Ugu, Judge.
All right. Ugu. All right, hello. Hi, okay, today is the plea deadline date, or is your client requesting a jury trial?
He is.
All right, if you'll step over in that line and confer with them on a jury trial date. Oh, Charles,
Yes.
let me speak to you real quick. Hello. All right, court is calling 2024 CR 011153, State versus Jeremiah Day. Can I have parties announced for the record for the state?
Ashley Jones,
Defense,
Irene Acosta.
and are you Mr. Day?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your clients?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Day, did you review the document entitled application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Judge. The state is going to waive counts 1 and 2 and proceed on count 3 only.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count 3, you're charged with tampering or fabrication, physical evidence with intent to impair as a 3rd-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes,
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Day, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 3. There's a $500 fine. State recommends deferred adjudication. This is the run concurrent with 2024 CC 737065. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be 40 hours of community service restitution. There be no contact with Carlicia, Karlashia Johnson. Anger management, TAP evaluation, follow recommendations, MRT, and no firearm possession. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in count 3, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State offers states exhibits 1 and all attachments, including states exhibit 1A.
Any objection?
No objection.
All right, when we were off the record, both parties had stated to the court that they had a DVD that they wished the court to review. And the court did review that, and there was no objections to the court reviewing that before the waivers and exhibits were taken into evidence. Is that correct, state?
Yes, Your Honor.
Defense, is that correct?
Yes, Your Honor.
All right, the state did have the court did have an opportunity to review the disc. All right, Mr. Day, did you review the document entitled Waiver and Consent to Stipulations with your attorney? Did you understand it? Court will accept into evidence states exhibits 1 and attachment, and so the record is clear. The only thing that the court reviewed or listened to was the DVD. The court did not review the other stipulations. Just give me 2 minutes. Let me listen to one thing on this DV again. All right, just 1 second.
Sure, Judge. Did the court have an opportunity to review my timestamp that I submitted?
After reviewing states exhibits 1 and attachments, I'll need the disc.
Yes, Judge.
Thank you. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Day is 19 years old. He would like to work as a roofer potentially soon. He does not have a GED. He does not have a high school diploma. He would like to obtain one. And he does plan on moving forward being a more functional member of society. He's very young. He's going to be living with his mother. And I believe that he has the support available to allow that to happen. But I do think that getting his GED or some type of diploma would benefit him. I don't believe that there's any other mental health diagnoses that I'm aware of. In speaking with him, aside from, I believe, ADHD, but I think getting his diploma would help.
All right. Have you ever had employment? Doing what? All right. Why are you arguing with your sister over a charger?
She started it. It was really that.
All right. I see now the reason why they're recommending the MRT. I don't know how getting into an argument with your sister, and how old is she? She's 16. You're 19. You're getting in an argument with a 16-year-old, and this turns into a weapon and destroying a weapon. So what were you planning on doing? Were you planning on injuring your sister? Then why would you even do this? I don't understand what's wrong with young people today. You're bringing nothing to the table. You don't have your GED. Public education is free. And as I tell everybody, people come over here from other countries, don't even speak English language. And the next thing you know, that person is the valedictorian of your school or first in your class, because other people don't want to take advantage of the free opportunities that you have here. Slaves were not allowed to read or write. And they ended up sometimes, to their detriment, to their death, learning how to read and write. And here you are with free education, and you don't take advantage of it. All you're doing is hanging around with your hoodlum friends, and I'm going to say hoodlum friends, because they're not up to anything. You're not up to any good. You're at the Bexar County Jail, and I'm sure your attorney told you not to make phone calls. You're not listening. And probably if you didn't make that phone call at the jail, you probably wouldn't even be here. And don't tell me you didn't know the phone was recorded, because every time at the Bexar County Jail, and I would tell my clients too, I don't know why you get an attitude with me, because I'll give you 180 days at the state jail facility to give you a little taste of what it is. I know that every time there's a phone call made from the jail, what ends up happening is they give the defendant's name, SID number, and they tell you that this call is being recorded. But you still going forward with that nonsense, you know, trying to injure your sister who's only 16 over a phone charger that probably neither one of you paid for. Your mom is probably the only person who's working, and you all are doing stupid stuff. And now, look at you now. You're in an orange uniform, no education, with a SID number, and now you're going to be on paper, and you're going to have this felony following you around wherever you go, because you don't want to get your education, and you want to hang out with some thugs because y'all are watching video games or whatever nonsense y'all are doing, Fast and the Furious or The Godfather, and think that this is what life is about. that whole little thing that I read in the waiver, you all could have ended up getting killed, running around with a gun. You and your friend. And then you know what would end up happening? Your mom would have been crying on the news, asking people to do a GoFundMe. I do think he needs some jail time. He has some issues. He has attitude issues, and he has learned nothing from this entire thing. So, counsel, do you want to tell me why I shouldn't give him a taste of the state jail facility to get his attitude in check?
Your Honor, I think he's been in custody for, I believe, 90 days now. And in speaking with him, he wants to get back to work. He wants to get his education. I think that that time period in the facility already, or in Bexar County Jail, has given him at least a taste of what it could be. And I think that in this situation, giving him the opportunity to get his education and get back on track is warranted. He's young, and I understand that he could be sentenced and go to a state jail facility, but I don't think that that would benefit him. I think that if we're looking at rehabilitation, getting his education, taking the courses that the state recommended, and doing what he needs to do while being supervised by Bexar County would better serve him.
State?
Your Honor, the defendant does not have much criminal history, at least in the way of any convictions. Given his age and given his acceptance of responsibility, the state would recommend going forward with our recommendation for deferred.
Do you have any children? Please tell me you don't have any children. Well, I want you to be truthful, but I'm hoping you don't have any children because you're not ready for them. Do you have any children? Probation, what do you think about the conditions of MRT and anger management?
Judge, I think those would be good. I would also probably add the safety course.
Okay, all right, thank you. All right, the court will sentence you to 4 years deferred adjudication. There's to be no contact with Carlicia Johnson. And you say that he would be living with his mom. Where is the 16-year-old going to be living?
That's his stepsister, Your Honor. She doesn't live at the same residence.
All right, so there'll be no contact with Carlicia Johnson. Proof of employment within 30 days, no employment as a home health care provider or with minors, regular reporting by Zoom or in person, regular random UAs, $100 hours of community service restitution. You're either obtaining your GED or you're going to obtain some kind of trade school certificate. Do you understand? Once he does that, the community service hours will be deemed satisfied. Anger management, firearm safety course, the MRT. The MRT is supposed to help you make decisions, correct decisions, think things through before you act. Now, with regards to the TAP evaluation, have you used any drugs in the past? No marijuana? No alcohol? All right, TAP evaluation, that can be done out of custody. I'm going to want field visits 1 time per month for 8 months. Probation, is there anything else? Anything else you need from the court? All right, this will run concurrent with 2024 CC 737065. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Good luck to you. You had better start making better choices. Yep, still has the attitude. I still think I should have sent him to prison as a condition.
Judge, may I be excused?
Yes. It still could happen. Michael Ogden,
Present, Your Honor.
Come forward. All right, so he has an active warrant. And what are you here for, counsel?
We filed a motion to set bond, Your Honor. I have conferred with the state on the amount. He has no criminal history. This
All
was.
right, let's go on the record.
Yes, ma'am.
Court is calling 2024 CR 010120, State of Texas versus Michael Ogden. Can I have parties announced for the record for the state?
Andrew Harris, Sadelman.
Defense?
Austin Hague representing Mr. Ogden.
And are you Mr. Ogden?
Yes, ma'am.
All right, defense, you're here to set a bond, is that correct?
Yes, Your Honor. We have filed a motion to set bond, and then we did request this hearing today. I'm present with my client, Mr. Ogden.
All right. So is there a proposed agreement or no?
There is a proposed agreement. I have conferred with the state. We've proposed $10,000 due to the lack of criminal history and the fact that there was no violence attached to this offense. They have agreed to that amount. If you want to confirm that, Mr. Edelman.
Can confirm, Your Honor.
All right, Mr. Ogden, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Michael Ogden?
All right, Mr. Ogden, has there ever been any mental health diagnosis with you?
No, ma'am.
All right, have you ever received any type of medication for mental health?
No, ma'am.
Have you ever seen a psychiatrist?
No, ma'am.
Okay. Has there been any type of drug use in the past?
That's marijuana.
Okay, and how long ago has that been?
Oh, that's been years ago.
When you say years ago, what do you mean by years ago?
20s?
Okay, when you were in your twenties, not the twenties.
Oh, correct.
Okay. All right. All right, any questions of your client?
Mr. Ogden, are you gainfully employed right now?
Yes.
You understand that you'll be required to come to all court dates in the future in compliance with your bond?
Yes.
Okay, and you and I have arranged for you to take care of a satellite bond today?
Yes.
And you understand you're going to be escorted from here to take care of that?
Yes.
Okay, no further questions, Your Honor.
All right, the court, based upon my review of the defendant's history and also based upon my review of what's in the current system, the court will grant your agreed order to set bond at $10,000. Ms. Ferguson, we can go off the record. Have you received any discovery in this case yet?
I have not, Your Honor. I have reviewed the file, but I have not received any other discovery.
All right, Ms. Ferguson, if you'll recall this in December for discovery, please. All right, we'll be back on December 17th for discovery. Ms. Ferguson will give you a reset form and then they'll take you to satellite.
Thank you, Your Honor.
You're welcome. Ashbaugh. All right. So plea deadline date.
Yes.
All right.
We received a plea offer yesterday. I've discussed that with my client. We're not inclined to accept that at this time, Judge. I've discussed with the state. I will have some pretrial motions that I would like to have heard prior to trial.
Okay.
I've conferred with the state and I can hopefully have those on file by the beginning of December, if that's okay, Judge, and sometime in December for a pretrial, contested pretrial motion setting.
All right. How long do you expect this jury trial to last?
The jury trial itself, probably a week.
I was gonna say 5 days. Yeah, 5 days.
5 days. Okay. Ms.
There's a lot, Judge.
Yeah, a lot of witnesses and officers. Yeah,
Okay.
Files like
late witnesses.
This big. I
This
haven't
big,
seen that.
yeah.
far. All right, Ms. Ferguson, I need a jury trial date. All right. And then with regard to your motion, just get with the coordinator and whenever you want them set, we'll hear them.
Okay, thank you, Judge.
You're welcome.
If I could just confirm. 21st. Judge, can I approach?
Yes.
Is there any way we could do the week right after that? Right after the 21st? I'm just taking my daughter to Disney World.
Oh, yes. Ms. Ferguson, can you do it on a different date?
And I'll confirm with the state on a good date for that.
The following week, maybe? But the question is, will she remember?
Probably not, but we will.
See, you're just going for yourself.
Yeah. Well, she might.
Yeah.
We'll see. Obviously, I don't want to take too many liberties. I could, but the week after, if that week of the 28th is. I mean, would the week after that work?
Put it in February. You put it at the end of February?
February 25th, Judge?
Yes.
We can review, well, never mind, I'll talk to you about it later.
Okay.
Okay.
Alrighty.
see if we'll get you the sign. Maybe, oh yeah, and Judge, I just talked to my client today and the state had no issue with it. My client's on GPS. He was requesting to go to his sister-in-law's house for Thanksgiving, still in San Antonio, I believe, just a few minutes away. So that's what he was requesting.
Any objection?
No, Your Honor.
All right, if you'll write up the order, I'll sign it.
I will, Judge. Thank you.
Sure. Paul Smith? All right, Paul Smith?
Yes, Judge. May I approach?
Yes.
It's my understanding from Mr. McCray that Mr. Smith may be in the hospital at this time.
Yes.
I know that the system hasn't reflected for a court date of December 12th, Your Honor.
Yes.
I'm gonna have on my vacation starting with December 11th. I've had my notice out.
Sure. When do you want it recalled?
Wanted to see, Judge, if we can do it early January as I have to meet with them and then get up to speed with the discovery.
All right, Ms. Ferguson, on Smith, can you put this for trial? I mean, not for trial, I'm sorry. The week of January 27th.
Sounds good. Thank you, Your Honor.
All right, what date? All right, so we'll do January 27th.
Yes, ma'am. I will go ahead and notate that.
All right, thank you. All right, Thomas. Oh, I said I'll talk to you about that. Amanda Drummond. Hello.
How are you on today, Your
I'm
Honor?
doing okay. How are you doing?
So far, so good.
All right, so she had entered a plea. And we're just recalling it for the TAP evaluation to see what they recommend.
That is correct.
They're asking that you be reviewed for the DDRF. All right, so what we're gonna do is we're gonna bring you back. And we're gonna bring you back that first week in January to see where we are, okay? And I'm just doing this so we can make sure that we find the right placement for you so that you won't fail, okay? Yes. Sure.
Whenever I went to drug court, they said that I qualify for drug court, and she was talking about the lifetime rehab. I don't know if that's something that maybe you have to look into, but they put me on Suboxone at the jail. So it has to be somewhere where I can continue my medication.
Okay.
That allows me to be on Suboxone while I'm in treatment.
Okay. All right, so what we're gonna do, we'll bring you back on January 9th, okay? So that'll be that Thursday. So you have your interview with them on January 6th.
Okay.
And then we'll know something by then, okay?
Okay.
All right, thank you so much.
Thank you. Happy holidays.
Oh, happy holidays to you too.
Okay, thank you.
Have a lovely day.
All right, thank you.
Yeah, more. I asked your probation officer, including Arizona officers, what does TCOOMMI stand for? She said, that's, I don't know. So when I came in, she brought this to me.
Oh, yes. Oh, that is so awesome. I like it. Texas Correctional Office on offender.
With medical or mental impairments.
Okay, awesome.
So I'll now be the only person in the courthouse besides you who knows what this thing stands for. Have a good day.
All right, you too.
Oh, and
Erik Cantu. Hello.
Hello, Judge.
Hi, are you all ready to proceed on the motions or no?
Yes, Judge. Motion to set bonds?
All right, so you're not ready to proceed on the motion to revoke?
No, not yet.
Okay.
Judge.
All right, court is calling 2024 CR 1237 and 2024 CR 1238, State versus Erik Cantu. Can I have parties announced for the record for the state?
Harris Edelman.
Defense?
Christopher Ramos for the respondent.
And are you Erik Cantu?
yes.
All right, defense has filed motion to have bond set in each of these cause numbers. State, have you had a chance to review the defense's motion?
Yes, Your Honor.
Is there a proposed agreement or no?
I think there's a recommendation, Judge. We're going to ask for less. We'd like permission to put on some testimony regarding his financial circumstance.
All right, and state, what are you requesting?
30,000 in each case, Your Honor.
All right, and defense, what are you requesting?
Formerly we were requesting 10,000 on both, Judge.
All right, now I know where we are.
Thank you.
All right, you can call your witness.
Yes, with the court's permission, the state would like to call Erik Cantu Senior.
All right, Erik Cantu Senior, could you raise your right hand for me, please?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Erik Cantu.
Erik
Cantu.
Senior, junior, because I have Erik Cantu here.
It's technically not senior or junior.
Oh.
He's spelled with a K, I'm spelled with a C.
Ah, okay, all right, thank you. All right, you may proceed.
Thank you, Judge. Mr. Cantu, for the benefit of the record, can you tell us how you know the defendant?
That is my son.
And was he placed on probation on September 9th, 2024?
Yes, he was.
And while on probation for the last 49, 50 days, has he been living with you? And is he working?
No, sir.
And for the benefit of the record, was your son shot by an SAPD officer several months ago or a couple of years ago?
A couple of years.
And as a result of the shooting, has he had an opportunity or physically capability to work?
The answer is no to that.
Okay. And as a result of him being unable to work from these injuries, have you and your son taken steps to apply for SSI or any sort of governmental benefits?
We have been on the SSI list for quite some time. He's almost there as completion. So yes, we are on that list.
So he's on the verge of being approved for SSI benefits?
Correct.
And once he's received SSI benefits, he will start receiving some sort of income.
Some sort of.
And for the benefit of the record, can you describe some of the medical injuries or conditions your son suffers from as a result of the shooting that prevent him from working? If we can just narrow it on the largest physical ailments that he has.
PTSD, severe anxiety, paranoia, and of course, his physical attributes are lack of long-term physical abilities, can't breathe that well, and of course, he still has a lot of injuries that are sustained throughout his body.
Now, specifically, his lungs were injured as a result of the shooting, correct?
Correct, and then he had a severe infection. They had to cut him open twice to go in and scrape his lungs, which is a very delicate part of the body.
Now, specifically regarding his lungs, as a result of the injuries to his lungs, it's difficult for him to engage in physical activity as a result of these injuries.
Correct.
Okay. Now, you understand we're asking the judge for a bond?
Yes, sir, I do.
And does your son have any sort of financial means to meet this bond?
No, he doesn't.
Are you in a position to contribute a little bit to this bond amount?
I can help him.
Okay. And how much of a bond do you think you or your family members and loved ones can come up to help him meet this bond?
I mean, based on the percentage you described per bond, we're hoping to get, 10,000 between the two.
Now, in this circumstance, if he is released on bond, do you foresee him having any reason other than medical appointments to leave the residence?
He will stay at home.
Do you think you could benefit from a GPS monitor to assure the court that he's going to remain at home?
We benefited from it before. We needed it, and we'll follow that.
All right. Mr. Cantu, this prosecutor may have some questions for you, but I'm going to pass you as a witness.
Mr. Cantu, you said that your son lives with you. How long has he lived with you?
Probably since 2008.
So for the
No, since
past,
he was 8 years old, I'm sorry.
since he was 8 years old.
Correct.
So for the past 3 months, he's lived with you continuously?
Correct.
And do you happen to have a black 4-door sedan at your home?
Correct.
Does Mr. Cantu use that vehicle?
I'm sorry, what was the answer?
He's not allowed to use that vehicle.
Pardon me, Mr. Cantu. I didn't ask if he's allowed to use the vehicle. I asked if he does use the vehicle. Does he?
He has used the vehicle in the past. Yes, sir.
Has he used the vehicle since September?
No.
Did you happen to have a meeting with Mr. Cantu's supervision officer on October 17th of 2024?
The supervision officer.
Or a field officer?
For the benefit of the record, Judge, I'd like to object. It does seem to go outside the scope of the hearing in terms of assessing his bond amount.
All right, that objection will be overruled.
So I can meet with anybody.
Would it surprise you to know that Mr. Cantu's supervision officer reported that a field officer made contact with his father, which apparently is you, on that date, October 17th of this year.
And this would be a police officer that I've met.
A supervision officer, someone from the Bear County Supervision Department.
Sir, I haven't met with him.
And so no one told you that Mr. Cantu needed to contact his supervision officer as far as you're aware? All right, thank you. No further questions.
All right, any further questions?
No, Judge.
All right, thank you for coming in.
Yes, ma'am. Thank you.
You're welcome. Do you have any other questions?
No, Judge.
All right.
Just
you can
argument
step down.
whenever.
The court will hear argument. It's your motion. You may proceed.
Yes, Judge. As the court has probably reviewed the MTR, one of the allegations includes that
I have not reviewed the MTR, but okay.
one of the allegations in the MTR, and I think it puts in the context what the prosecutor was asking, is that Erik was seen driving, and the circumstance or the context is apparently he went to report to the allegations that he went to report to the probation office. When he left the probation office, another probation officer followed him and observed him driving off in the car, and then that's the allegation in a vehicle. So that is the context in which the MTR that we're looking at right now. So I'm asking the court to be mindful of a few things in assessing the bond. One, his lack of ability to work, his lack of financial resources. He's on the verge of receiving SSI, but that has not been approved yet. So we're asking the court to be mindful that he does have ongoing medical appointments, significant injuries from the result of the shooting, and we're asking the court to be mindful that that he's having to deal with all of these circumstances. So we're asking the court if the court can keep that in mind as it assesses the bond. We're asking for a bond. I mentioned $10,000 on each case, but it sounds like the family may not be able to afford that. So we're asking for whatever the court can extend in that circumstance. We're set for an MTR on September 10th, and we'd like to, at that point, make our proposal to the court at that time.
All right, state.
One point of clarification. Did I hear correctly that you said September 10th or December 10th?
December 10th, excuse me.
I just wanted to be sure. Your Honor, considering the relative rapidity with which Mr. Cantu is alleged to have violated the conditions of his supervision relative to when he was placed on that supervision, it does not seem that Mr. Cantu is very good at, shall we say, following rules. And considering that the bond amount on each of his previous cases was $15,000, it begs credulity to think that a bond amount less than his original amount would be appropriate given these considerations.
And Judge, if I can just respond to that very quickly.
You have a right to respond. It's your bond.
So I ask court to be mindful that the prosecutor is correct. 49 days has gone by between the day he was placed on probation to the day that the MTR was issued. 49 days. I offer the court to be mindful that he's 19 years old. He's experienced significant traumatic events. This allegation stems from him trying to go to the probation office to do the right thing and maintain his supervision with the probation officer. He was trying to do the wrong thing. I think that some of the trauma that he experienced kind of contributed to make him taking the wrong steps in doing that. I ask the court to be mindful that prior to the shooting, he has no criminal history, not even juvenile history. So yes, there is some truth to what the prosecutor is saying, but I think if you put it in a larger context, it can be explained as to the young man his first time on probation, trying to get this right, doing the best that he can, reporting to probation. He just went about it the wrong way. And we're asking the court to consider all of that as it assesses its bond amount, Judge.
All right. In each cause number, the court will set your bond at $30,000. The court will order full GPS and the court will waive the fees for GPS. And this will come back on December 10th for a contested hearing.
Thank you, Judge.
Thank you.
Are we excused, Your Honor?
Yes.
Also, I was Judge.
Quickly as possible so you can go through satellite. So here's the thing. I don't know anything about your case. You're charged with unlawfully carrying a weapon in prohibited places. You have the right to remain silent. Anything you say can and will be used against you, maybe at trial. You have a right to have an attorney appointed to you if you can't afford one. My understanding, you have an attorney here, is that correct?
Yes, Your Honor.
All right. If you need one appointed to you, you'll have to do an interview. They'll swear you in. They will have you put in your financial information to see if you qualify. You have a right to have an examining trial, but has this case been indicted?
I believe so, Your Honor.
All right, so this case has already been indicted. You will have ample opportunity to speak to your attorney. If you wish to, you can speak to law enforcement. You don't have to speak to them if you don't want to. But once you start speaking to them, if you decide to speak to them, you can stop speaking to them at any time. If you wish to speak to them, you have a right to have your attorney present. Do you understand?
Yes, Your Honor.
All right, and I will need you to sign here. And by signing this, you're merely stating that I've gone over these rights with you and that you understand these rights. Do you understand?
Yes, Your Honor.
Usually I would go slower than reading this, but I'm trying to get you to where you need to be so you can make fun.
Your Honor.
All right. All right, thank you.
Thank you, Your Honor. Thank you, Your Honor.
All right, who's here on David Johnson? David Wayne Johnson? Counsel, are there any applications? All right, court is calling 2023 CR 6703, State versus David Wayne Johnson. Can I have parties announced for the record for the state? Defense?
Tony Adandas.
And are you Mr. Johnson?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance penalty group 1? 1 to 4 grams, that's a state jail felony. I'm sorry, that's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred, that goes to Vajon. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
According to the plea, the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offenses charged, how do you plea? Guilty, not guilty, or no contest?
Guilty, Your Honor.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied with deferred adjudication. Are you proceeding with sentencing?
We'd like to, yes, Your Honor.
Anything you wish to say on behalf of your client?
Just let the court know, Judge, he's been in jail since early October. He has his job waiting. He works at IHOP. He's a cook there at IHOP. He still has a job available and waiting for him. He also has an apartment that he's trying to get back to before he loses it. So we're asking the court to grant his application today.
All right, so Mr. Johnson, how long have you been using?
About a year.
Okay, what made you start?
The stress.
Okay. And I'm asking you these questions because I'm trying to figure out what conditions to give you so that you can be successful on probation. All right, do you have any children, any support system?
I got a brother that live out of state.
All right.
And my girlfriend, she's at home right now, I think.
All right, would that be Miss Gray or no?
Yes, ma'am. And my job, of course, they'll support me.
All right, so is the only family you have your girlfriend and your brother? Is there no other family members?
Well, they are, but they all out of town.
Okay. All right, this is what the court will do. The court will sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months, 90 sober meetings in 90 days, and out of custody will be a TAP evaluation. Is there anything else you need from the court to be successful?
No, Your Honor.
Probation, is there anything else he needs? All right, we can go off the record. If there's anything that you need, or if you see that you're about to start using, pick up the phone, call your probation officer. If you feel they're not addressing the issue, you can always come back to court. The state wants you to succeed on this probation. That's why they offer it to you. Your attorney believes that you can do it, and you believe that you can do it.
Yes, Your Honor.
Yep. So the key is to stay vigilant. Make sure you do your sober support meetings. Sometimes people don't like to do them, but once you start going to them on a regular basis, then you start enjoying meeting the people, and you get to discuss whatever pressures you have without the fear that maybe somebody's going to say what you said. You understand?
Yes, Your Honor.
All right. Good luck to you. Okay.
Thank you, Your Honor.
You're welcome. Have a good one.
Thank you. Maybe to
Yes, they'll probably release you at midnight.
Thank you, Your Honor.
All right.
if that early.